Now, we're going to combine these two segments up here. Ross, we have attorney Benton Ross Watson with us. Ross, welcome again to the show. How you doing?
Great to be here, man. Great to be here, as always.
Everybody's enjoying it. Let's get this mic out of your phone. Scoot over here so we can get you on the screen. The girls want to see you, not the microphone. Okay? Now, Ross, I sent you this, and we're going to discuss this. Well, first of all, tell everybody how they get a hold of you.
Oh, here in Cameron, my primary office location, 105 East Main. That's here in Cameron, right next to the courthouse. Big milk cow painted on the side of the building. You can't miss it. Phone number is 254-605-4140. That's 254-605-4140. Email is Benton, Benton, at watson.legal. So that's just my name, Benton, at watson.legal.
Fantastic. So you give us a call. I'll tell you what, ladies and gentlemen, if you got questions about these penal codes,
or you can call in today, right?
Call in today, 254-697-6633. I'll tell you what, if you don't call in to get to talk to an attorney and not be charged, you're crazy. I mean, you got free legal advice here. Come on. All right. Ross, we talked about Penal Code 941. I highlighted a bunch of spots that were I wanted clarification on. I'm sure you got some case matter. And then I also have this article. What do you want to do first?
Either way.
We'll do the article last. Okay, go over Penal Code 941 for us. And you saw my highlighted spots. Let's talk about it and clarify some things.
So you see there's two portions to the 9.41. One of them is that you're either in lawful possession or you've been unlawfully dispossessed of the property. It means one is talking about when you have possession of something and somebody is trying to take it from you right there at that point in time. The other one, subsection B, is referring to a situation where they have been successful in either kicking you out of your real property, your place of residence, or taking your property from you. And so in one of the situations, it just talks about you being able to use the force that you reasonably believe is necessary, immediately necessary, to prevent them from trespassing or from taking your property. Whereas the other one says that you have to use that force immediately or in fresh pursuit of the dispossession. So that means after they've taken the property, let's say, because it's a lot easier to understand a personal property point if somebody has stolen your property and they've been long gone, and it was 2 days you've been on vacation, you come home, and then you find out later in the week that, hey, it was Joe Brown over there on the other side of town that took your property. You probably wouldn't be able to use force to go recover your property because it wasn't immediately or in fresh pursuit. So fresh pursuit.
Well, I'll tell you what, clarify that, because that's one of my common questions is to what is fresh pursuit?
Really, this goes back all the way to the England common law days when we were under the crown. The police officers would be in fresh pursuit when, for instance, they would try to catch a criminal and he'd run, and they would chase him. This has application even under the Fourth Amendment in cases where normally we hear that our house is our castle. We've even talked about that in regard to protecting our castle with our weapons. Well, the one exception basically that police officers have, if they're chasing you, you can't just run in your house. They can break down your door if they tried to stop you and you fleed the scene and they're chasing, they gave chase, and then you try to go hide in your house. They're not going to need a warrant for that. They can break down your door and your castle is meaningless.
Good to know.
Okay, and so yeah, and I mean that would be probably fresh pursuit is sometimes a fact question, but I can promise you that if you see this person at all, even if it's a long distance, if you see them and you know that's the person that's got it, and you know that that's the person that committed the crime, and you give chase, that's going to be fresh pursuit.
There's no distance regulations on that? I mean, it gets to a point where you're hunting this guy down.
Hey,
let me give you an example of what I say and tell me how you'd fit this in, or if you think I'm wrong, or that's a good idea, or whatever. I say, fresh pursuit with law enforcement is basically till they can't see the guy anymore, then they re-engage, or they get the hold on, and then they get the guy. I'm saying for personal protection, fresh pursuit would be maybe your property line, or maybe the first city block, because then it looks like it's hunting. Because there was an incident down in Austin. Some guy steals this guy's wallet or his girlfriend's purse, and it had her driver's license in it, where she lives, keys to her house, all this kind of stuff. So he chased this guy, ended up in a dark alley, he ended up getting off of the thing, but it looked bad because it looked like he shot him right there, and he traveled so far to get him. So that's why I'm always concerned about the distance of fresh pursuit.
And then that's when there are a couple of cases where somebody, this was under the old unlawful carry, and we don't really have any of the newer cases since they've changed the law some on the unlawful carry statutes. But a shop owner chased a man down the street with his weapon, and you can't, if you remember, under the unlawful carry, you can't display, a handgun out in the open if you're not on your own premises.
Right.
And so when he's chasing this guy that was trying to commit even a heinous crime in his business, right? Once he got so far out on the street, it was not his premises, and so he could be charged with unlawful carry. And that sucks from that standpoint. But I think here, when we talk about being able to use the force to recover it, I think you would have the same rights as a police officer as far as a fresh pursuit. Now, like I said, it's a fact question, but for sure, if you're seeing this person and you're able to give chase to this person, right, that is a fresh pursuit. Okay, now any more than that, you're getting into gray area. We don't know who's gonna find to be what in fresh pursuit.
I'm just thinking how easily it can go from a 9.41 to a 9.42, which is deadly force.
Right,
because,
right. And you could, but you can use a 9.42 if you're justified in a 9.41.
I understand, but what I'm getting at is if the difference between following, waiting for maybe law enforcement to come and assist you, as compared to you going cornering him, and then it escalated when it didn't really have to escalate.
And for people, everybody that knows, what we're talking about now under 9.41 is not the deadly force provision. So there are other requirements if you're going to want to use deadly force to recover your property. And for that, what Matt is referring to is they've got to be, the person has to reasonably believe that the land or property cannot be protected or recovered by any other means, or right, that any other force would put other people or the actor, meaning you, into danger of serious bodily injury or death. So it's got to be, it's or, so it doesn't have to be both of those, but it's can the property be recovered by any other means? And what Matt was referring to is basically saying, could you call the cops? Could you wait on the cops to get there and help you recover the property instead of doing it on your own? Right. The other one is, would waiting, okay, would using any other kind of force cause death or serious bodily injury to other persons? Could I guess you could always argue you feared that the police, if they helped you, they would get hurt in trying to go recover this property. I don't know I don't know. I mean, you could probably say this, but this is, I think what I was saying, I gave an example several, maybe 2 months ago about, let's say you come home and a guy's got your jewelry, your wife's jewelry, and he's running. You've never seen this person before. Do you really have any other means to recover the property? You have no idea who he is, right? You have no idea where he lives, and let's say you're not in Cameron, okay? Let's say you're in Houston, right? Is calling the cops really an option?
Probably not, no.
So, but then you have to ask your question, right? Is insurance, if you have the jewelry insured under renter's insurance, is this a recovery of the property, or is it merely compensation? And so I think here is some ambiguity that we don't really have any good answers to. I have some treatises, and I actually have 2 or 3 different, maybe even 4 treatises that I go to whenever I have questions that I don't understand. And on this point with insurance, 2 treatises say one thing and 2 of them say another. And so if you have it covered under renter's insurance, do you really need to go?
See, I bring that up in my class all the time. I say, you get a good spin doctor, prosecutor, and they're going to say to you, you have no other way to recover it. Do you have insurance for that vehicle? Yes, I do, full coverage. Ladies and gentlemen of the jury, he has a way for compensation. He didn't have to do this.
And see, I argue that's not recovery of the property. Just because you get compensation doesn't mean you recover that property. But I'm a defense lawyer.
Now I want to make something clear to you and to everybody listening, because some people say, Matt, why are you so pacifist? I'm not a pacifist. I'm a wisifist. Okay, it's like the martial arts expert, the black belt, the master of defense, right? Does he really have to do? He knows he can stop this person. But why? I already know I can do this. I already know I can stop him. I already know I can use deadly force. I know I can do everything I know I can do. But since I've got that in reserve, let me use all my other stuff up first. Because I don't want to change my lifestyle. I don't want to lose money paying it to you, Ross. I'd rather keep it myself instead of paying you to defend me. So until it gets to the point where, okay, all those other measures haven't worked, so now I got to pull out the big boys and do it. That's where I come from. And that's why I try to get across over this radio show. It's like, don't go to deadly force when force, verbal command, hey, put that down, would work. So that's why I'm always being anal about definitions, what it means, clarification, and how quickly things can get spun out of control.
I do want to point out, if you notice, if you go and read 9.42 and 9.41, you're going to see that there is no excuse for retreat like there is in the regular deadly force to protect persons statute, which is 9.31, 9.32. Now, under the old law, they required you to assess whether or not you should retreat in the situation. That goes to your reasonable belief, in other words. But I don't think that the court should read in a retreat requirement, like they did under the old law. You were required to retreat if you could, because here it makes no sense. Why would, if somebody's dispossessing you and you could use it in fresh pursuit, why would you retreat? You can't. It's hard to apply both of those reasoning. I mean, you can always retreat if somebody's trying to get away from you, because they're retreating.
Okay.
So why would it require you to retreat when it authorizes you to use deadly force against somebody who is retreating from you?
I guess it depends what day of the week it is, what personality your judge is, what facts they administer into the court, and what the jury's thinking at the time that they're deciding your fate. From what you tell me.
But again, I think I sent you an email with it that a long time ago, that out of those 4 treatises, 2 say that you're going to have to retreat because they believe that at some point in time the courts will infer their own retreat requirement, and the other 2 are sided with me.
Well, don't they nullify each other, and then you don't have to even use?
Yeah, that's right. So hopefully, that's what I think the treatises see that. Yeah, it's unreasonable, but their courts are often unreasonable.
That gets under my skin, man. It really does. Here you have a law-abiding citizen trying very hard to do things in a proper manner. The criminal doesn't give a darn. They're going to do whatever they want. Carry a gun without a license, break into your home without care, hurt you if necessary. They don't care. And here, the law-abiding citizen wants to do it right, and then has to fight again in the courtroom.
Right. Which is a good segue to the next article you wanted to talk about.
You want to talk about that article now? Okay. All right. We're going to be bouncing around here. I saw this article, and it says, customer fatally shoots man who killed bar manager. This is Arlington, Texas. Police say a customer at a North Texas sports bar fatally shot a man who had just killed the restaurant's manager to prevent further loss of life. Officials said 48-year-old James Jones walked into Zona Caliente sports bar in Arlington on Wednesday evening and fatally shot the manager, 37-year-old Cesar Perez. Police Lieutenant Christopher Cook said a customer then fatally shot Jones. Cook said the customer was carrying a handgun under the Texas Concealed Handgun License Program. Cook said, by all accounts, he decided to engage the shooter because he wanted to prevent further loss of life. Witnesses told police Jones verbally confronted Perez before killing him. I don't like that word. Police don't know whether they knew each other. Okay, Ross. Killing him, it's more like slaughtering him, taking him, it doesn't give enough effect. But talk to me about this.
So it's hard to keep up. Some crazy guy walks into a bar and shoots the manager, and then all of a sudden a good patron that was in the bar turns around and shoots the crazy guy.
Well, first of all, everybody's probably screaming, "Hey, it's a bar! You can't go into a bar with a gun, right?"
Who know? We don't know what really was looking. I mean, who knows what everybody was saying in there? I mean, it was pretty.
Well, first, ladies and gentlemen, let me make a comment here, because in most cases, a bar.
Oh yeah.
Is a 51%
I get what you're saying.
location. You want to go? You want to take that now?
Yeah. So
yeah. Is it pertaining to this topic?
I don't know.
Okay, let's put him on the air. Hold on, Ross. Let's see what we got. Just tell me when you're ready, Alan.
Yeah, you're on the air. Go ahead.
Hello, caller.
Good morning. I have a question about some people they have their license, but they walk into a grocery store and they have a handgun, I suppose, like it's supposed to be. But I get paranoid and I see kids around us, in the grocery store inside. Is there anything that can be done about that? To avoid people from parents getting hysterical or something like that?
Well, yes. To answer that particular question, to avoid the parents from getting hysterical would be information, would be understanding, would be calming down. But now let me go another direction with your question. The people who are licensed here in Texas are very, what am I trying to say? They have been through the ringer when it comes to checking them out, background checks, the whole work. Very good people carrying weapons, either concealed or in the open. Granted, there are some from time to time who may go outside the bounds of legalities. So if they're doing it properly, in a professional manner, not carrying their gun in a threatening manner, that's just one of those things here, ma'am, in Texas. That person has that right to do it. Now let me make another comment though. That's why I push the concealed carry badge. I know I have a lot of opposition to this, but when a person decides to carry in the open who is licensed under the concealed carry or the license to carry permit, carrying a license to carry badge just shows, hey, I'm a license to carry owner, no sweat, don't worry, no foul. And I've done this test many a times. I've gone into the supermarket. You may have seen me. I don't know if that's the case. And one day I'll go in without the badge on, and people look at me, but I handle myself in a professional manner where it's no big deal. Other times I'll go in wearing my concealed badge right next to my gun, so people see the badge and the gun, and nobody bats an eyelash. And I would do that for your benefit, the person who's looking at me. I do it for their benefit to put them at ease. I have the right to carry this. I'm showing you I'm legal. I'm trying to put you in a calm mood. Because I have that right, I don't want you to take my right away, because I would never do that to you. I would fight for your rights that you have. It's just one of those things you got to deal with, and I think education, learning both sides, is a great way to start. The person carrying the gun better not be stupid, better not be foolish, better not be reckless in their carrying of it. And people, there's no law that can keep them from doing it, but I'll tell you what, public opinion and stress on that person saying, I think you're doing that in a poor manner, is one way to curtail that problem. So you can look at this many different ways.
Another thing you could do is
Okay.
another
Thank
thing.
you, sir.
Oh, well, another thing you.
Appreciate it.
No problem, man. Thank you for calling.
Another thing that you could do is you could talk to the grocery store owner and you can tell them to put up a sign that says, no one is allowed to carry here under the license. It's got to match 30-06 and 30-07. But you could go to the grocery store owner and ask him to put up a sign for that purpose to prevent people with license to carry to enter those premises while carrying a handgun.
That is true. And I would also recommend they don't, because with a click of a button, you can tell thousands and thousands of people who have licenses to carry that this location is not willing to allow you to protect yourself with the rights here in this state, and they're going to take their money and go elsewhere. So you can do it. The store owner or whoever can put up that sign, but watch out, your revenue is going to decrease big time, because I will not donate my money to buying groceries or buying whatever at a location that takes my right to defend myself. I'm not going to do it. So 254-697-6633. Ma'am, I appreciate that call. It's a very common question, and I think it's because in the last 20 years, more and more PR, political correctness, and all this kind of stuff has killed us. It wasn't uncommon at all to see shotguns in a vehicle, people going hunting after they go to school. It's no big deal, but we got this paranoia for no reason. And why? I just don't understand why somebody who sees somebody who's got a weapon concealed, it shouldn't be a matter at all. If you're carrying a weapon concealed and somebody knows you got it, you're wrong. Okay? Conceal that weapon better. If you're going to carry it in the open, you do it in a professional manner. But I know if I see somebody with a gun around with it, great. Something goes down, I know I got somebody to back me up. Okay? So many different ways to look at it. But I think the bottom line is you must know what you're doing. Now, here's another problem I've got. constitutional carry, I'm all for it on one side, where anybody can just go carry the weapon. Constitutional carry for the basic definition of the term. However, I cannot stress enough, you better freaking do some training. You better know how to use that gun, because a woman like who just called will have a concern, rightly so, if you're being an idiot carrying a gun in a reckless manner. You deserve everything that you get, okay? If you're gonna, and I say, if there's no law to stop you with constitutional carry once it passes, but there is no law to say that I can't verbally speak over this microphone or to you in person or to do something and say, look, if you're going to carry constitutional carry, you better do some training, okay? That's my thought. 254-697-6633. What do you think, Ross? I get passionate about this. Okay, anyway, we're back here. Let's clarify this bar thing. I was saying that 51% sign is because they're consuming, based on Texas Alcoholic Beverage Commission, they determine when you're getting your license if it's going to be a 51% business or not. What that means is the sale or service of alcoholic beverages for on-premise consumption surpasses 51% or more of its income from those service and consumption at that premise. And there'll be a special sign. If you go to like a 7-Eleven or a Sefco to get your Morning Joe premium coffee, okay? Or your dark chocolate cherry nut nutritional bars, Caveman, which are, if you go to those locations where they sell the alcohol but you don't consume it, you're going to see one of those blue frame signs that says the unlicensed possession of a weapon in here is unlawful. So let's take it from there, Ross.
So after looking into it more, they said that this was a blue sign entity, which would mean that they are licensed to sell alcoholic beverages to some degree, but the amount of sales did not amount to 51%
For consumption.
for consumption. And so if they didn't have a sign matching 30-06 or 30-07, the gentleman would be allowed to carry his concealed handgun in this place. And so, because he was licensed. And it's not to say that anyone could just carry a weapon in there. They would have to be licensed, because 46-2, says that you cannot, it's a third-degree felony to carry a handgun into a place licensed or permitted to sell alcohol. It doesn't talk about a distinction between 51% or regardless of, you don't have a license, presumably you are going to be committing a third-degree felony just by taking it into any establishment that sells alcohol.
Let's clarify that one more time. If you go to a Sefco or a 7-Eleven or a Quicks or something like that, and they're selling the alcohol, it states if you're unlicensed and you're carrying it, you're in major trouble. Now, if you're licensed in those locations, you're fine.
You're fine.
Unless you're going to a place of 51%.
51%. And so he could have his license to carry there, but initially, Matt and I didn't know that this place was a blue sign entity, meaning they were less than 51% in their sales. But and we said we were surprised that he did not get charged with some other kind of criminal activity. And in fact, he could be convicted for unlawful carry if he was in an establishment that was a 51% establishment and they had the effective sign, and he could possibly at that point also have been unable to carry, period, and maybe possibly been charged under 4602 itself. And so I have a case. There's a case called a bond, and in that situation, instead of a gun, he had a club, one of those illegal clubs, and he was there at a club, and a security officer who was not a police officer but was a licensed security officer. There were a big brawl had broken out, and he had asked this gentleman to help him. He had asked the defendant to help him, and he gave him his club because it was a really big time bad brawl and he needed help quick. And this gentleman jumps in like a good Samaritan and helps the security officer quell the threat and dissipate the situation and kick those people out. And as he's kicking them out, the police were also being called, and they're driving up in the parking lot and they're throwing them out, and the police officer sees this guy with the club in his hand, right? And instead of going after the people who caused the problems, go straight after this good Samaritan and ask him why he had the illegal club. And he tries to hide the club for a second, but it didn't work. And he ends up getting in trouble for having the club, even though that he was basically commandeered to help. And he thought that he fell under the law there's a law in Texas that requires citizens. I don't know if it would be constitutional or not. We don't know. There's a couple of cases indicating that it may be unconstitutional, but assuming that it's completely legal, police officers in Texas can require any citizen at that moment to help quell a threatening situation. They can commandeer you. They can require you to help them. He thought, since this was a licensed security officer, and if he had been in uniform, there's some things that would have made this true. Okay, that this, even though he was a private security guard, he could have enlisted this gentleman to help him, right? But he didn't have the uniform on. He didn't have a couple other things that were required. Even though this guy knew he was licensed, that wasn't enough. See, even though he made a mistake of fact and a mistake of law, right? It didn't help him. It didn't help him in the courtroom.
Okay. Time's ticking away, so let me finish it up with this. Ladies and gentlemen, I want to wrap it up like this before Ross tells us how to get a hold of him. I can't stress this enough. I stress it in my classes. You need to know this law. You sign an affidavit stating that you know, have read, and understand these laws. They must be burnt into your brains, okay? I can only give you an overview of it because we only have a 5.5 hour class, okay? So you need to burn that in. You also need to know how to handle your firearm. You also need to know how to handle yourself under duress, because I'm telling you, when you start stressing out, anything you think you knew about shooting a piece of paper goes out the freaking window. Shooting a piece of paper is fine. You know what that does? It tells you your gun works. But do you work? Can you shoot on the move? Can you handle a malfunction? Does your brain work when it's supposed to? It's like, do I even need to be here? Can I run away? The first thing I think of is, can I get out of here? Can I leave? Or is there somebody in danger? Do I need to help them? That's the kind of person I am. I'm going to, like, if somebody needs help, I'm there. Okay? And then I want to evaluate. You got to be able to evaluate on your feet when it's happening. And if you don't train your mind, if you don't train your body, you're going to be ending up calling Ross here. And Ross, how do people get a hold of you when they screw up like that? How's that for a segue?
105 East Main in Cameron again. Got the big milk cow painted on the side there. You can't miss it. My number is 254-605-4140, 605-4140. And my email is benton@watson.legal. That's my name, benton@watson.legal.
Fantastic, Ross. I can't thank you enough for
Thank
coming
you.
on. And man, thank you for the call. It was a great call.
Yeah, keep calling. Keep
going.
bringing them in.
And I'll tell you what we're going to do. We're going to take a long break, and when we come back, we'll go over our not highlights, but what's going on coming up in this month, and get ready for The Voice. So we'll see you on the other side.
Capolino John
Thanks,
Krebs
man.
Law Firm in
Thank you.
Cameron prides themselves